Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest today is Dustin Marlan, Assistant Professor at the University of Massachusetts School of Law, and we will discuss his article, Unmasking, the Right of Publicity. So welcome to the show, Dustin.
Thanks for having me, Brian.
Yeah, so I thought maybe we could start for listeners who might not be familiar with the right of publicity and how it works, at least from a kind of a legal doctrinal perspective. If you could say a little something about what the right of publicity is and sort of where it came from. What's the sort of backstory of the right of publicity?
Sure. That's a good question. And I'm not sure that anyone really knows what the right of publicity is exactly. But it's one of two personality rights that we have, the other being privacy. Laws vary state to state because there's no federal right of publicity. And I believe 38 states have some version of the right of publicity in effect, either through statute or by common law. And it's generally agreed that the right of publicity is the right to control the commercial use and economic value of one's persona. But that definition of persona tends to be fairly unclear. Some states limit it to name, others interpret it more broadly to name or image, or name, image, and likeness. And the prevailing consensus today is that persona refers to harm to the objectified image of a person as represented through monetary value. And this is distinct from the psychic harm to feelings, emotions, and dignity protected under privacy law. Put another way, the right of publicity is currently a transferable property right, and one's external image is separate from privacy, which is rooted in the inner person. Publicity law comes from the 1953 Second Circuit Court of Appeals decision, Haelan Laboratories versus Topps Chewing Gum, or at least that was where it was first articulated by Judge Jerome Frank.
Okay. So prior to this 1953 case, which sort of is the lodestar for kind of the term right of publicity as we use it today, before that happened, what was the lay of the land? Like, what did it look like? Were people able to monetize their sort of personality in any way, or was it just not an option at all?
Well, there was privacy law, but before then, there hasn't always been a right of publicity, but there's been a privacy right since the late 1800s, when that was popularized by Warren and Brandeis's influential law review article, The Right to Privacy. But on the publicity side, as I mentioned, Judge Jerome Frank was the first to articulate a personality right that was public, that was transferable, that was property-based, and that was distinct from the harm to feelings and dignity protected by privacy. And as I mentioned, Haelan Laboratories was a case decided by the Second Circuit, and there Judge Frank held that a baseball player could license to a third-party chewing gum manufacturer the exclusive right to use his image on baseball cards. No, I was going to say Halon was really a breach of contract case.
Well, I want to talk about Halon in a little bit more detail, because I think it's really central to your article, or rather kind of Judge Frank's sort of ideas as expressed in Halon are really central to your article. But I was wondering if you could say a little something. And I know that you've said that sort of the right of publicity varies a lot from state to state, but if you could outline sort of like in a general, broadly speaking sort of way, what does it enable people to do? In other words, who can really claim a right to publicity, and what do people tend to do with it?
Yeah. So the right of publicity is, as I mentioned, the right to the economic value of one's persona. And this is something that has historically, stemming from Frank's interpretation of it, been one that's exclusively commercially focused, and recovery under the right is typically limited to economic harms. And if you're a public figure who has an economic worth in one's personality, then this is probably the right for you. But under this formulation, commercially focused, many public figures who suffer dignitary and emotional harms from non-consensual use of their identities don't have recourse. It's also not something that private figures can typically invoke because their identities lack that commercial value. And so they're denied under the law their ability to bring publicity claims. And they can't bring privacy claims either since they've let their images enter the public sphere.
Okay, so imagine I was like, say, a celebrity of some kind or a public figure whose name or likeness had some kind of commercial value. How would I use the right of publicity in practice? In other words, sort of what would I charge people for?
Well, I think you could charge people for using your identity in an unauthorized manner. I mean, take, for example, the singer Tom Waits, who didn't want his songs to be used in commercials. You know, he could invoke a cause of action saying that I don't want you to use my name if the state allows it. I don't want you to use my image, my likeness, my songs. He's a really raspy voice, for example. So it was obvious in the commercial at hand that this was really something that was a performance that he was unauthorized, but he was also limited by the commercial ability that his image had this commercial value. Had it not had that commercial value, he most likely would have been without recourse. For example, if it was something that was purely reputational harm, if it was purely harm to his feelings and dignity, that would not have been enough under the modern right of publicity.
Okay, so for contemporary scholars and maybe for policymakers as well, is there a consensus about why we have a right of publicity and what it's supposed to accomplish?
Not really, actually. The right of publicity kind of lacks a coherent justification for its existence as a purely commercial and intellectual property right. Most of the prevailing theories tend to focus on natural rights and economic incentives that are imported from other branches of intellectual property, as opposed to privacy, which tends to focus more on personhood or autonomy based theories. For example, economic incentives, like in copyright law, are sometimes used to try to justify the right of publicity, but many celebrities with commercially valuable identities engage in activities that they themselves generate a significant amount of income. And the commercial value of their identities tends to be a byproduct of their performance values. Locke's labor theory also isn't something that tends to be all that helpful in the personality rights jurisprudence context, given that the person who labors for a property right should prevail in the case of opposing claims there. But it's not at all convincing that we should assign the value of the celebrity persona based on a natural rights theory when that persona tends to be created and influenced by society at large rather than the individual identity holder.
Okay, so if I'm understanding you correctly, then we've sort of got theories of justification related to other categories of what we call intellectual property, things like copyright, patent, trademark, and so on, that seem to be relatively coherent, or at least offer a story that you can either accept or reject. And it sounds like those theories don't track well onto the sort of right of publicity as it exists or as it stands in the various states that provide such a right.
I think that's accurate, Brian.
Yeah. Yeah. Okay. Well, so in your paper, what I thought was really interesting was the way you looked back at the Haelan case, which is sort of like this enigma wrapped in a mystery, because it doesn't really explain why it's doing what it's doing in a kind of satisfying, fulsome way. And you offer, I think, a really intriguing and rich theory about why Judge Frank would have reached the conclusions that he did. So I was wondering if you could just say a little bit more about the background of Haelan, sort of the context in which the court was approaching the problem that was before it, and sort of what happened.
Sure. So, I mean, the thing about Haelan was it was really a breach of contract case. And the facts involved Haelan, a chewing gum manufacturer, entering into a contract with a professional baseball player that provided Haelan with the right to use that player's photographs to be sold with Haelan's chewing gum during the time frame of the contract. The defendant, Topps, was also a rival chewing gum manufacturer who deliberately induced the baseball player to contract with it to use the player's same photograph during the terms of Haelan's contract. Obviously, Haelan didn't like this and tried to defend, and the defendant then tried to say, well, the contract was just a release of liability for using that photo. Judge Frank disagreed, though. The Second Circuit disagreed, and Frank held that the baseball player, or rather Haelan, held a transferable licensing right from the player in the value of a commodified image or persona. And no court previously recognized the persona as this alienable economic consideration. And this description of a property right in the personality, this outer personality, was really in contrast to Warren and Brandeis's conception of privacy as this personal right protecting solitude, inner feelings, and dignity. In other words, the right to be left alone. So publicity becomes this outer property right, privacy, this inner psychic right. And so there was this division that Judge Frank created between the outer personality and the inner personality.
Yeah, and as I understand it, this sort of reification or propertization of the personality as sort of an alienable property right that somebody can sell to someone else is still kind of pretty controversial in terms of thinking about sort of what the right of publicity is and how it ought to work. Am I right there?
It is controversial, and many scholars don't understand why publicity became bifurcated from privacy, as Frank gave no real rationale for doing it beyond saying, well, celebrities would be they wouldn't like that they were denied image revenues, as a result of somebody else using their publicity. But what I find is that Frank's scholarly works were very much focused on this psychoanalytic understanding of the personality. He was very influenced by psychoanalysis, which divided the self into an outer public self, such as publicity, as contrasted with an inner private self, as invoked in privacy. Frank was this leader in the American legal realist movement, legal realism being the theory that law derives from social interests and public policy rather than just abstract rules. And so judges should use social interest and public policy concerns when deciding cases. And Frank's particular judicial philosophy tended to be heavily influenced by psychoanalytic thinkers like Sigmund Freud and Carl Jung. And so his work came to be known as a psychoanalysis of certain legal positions, or a jurisprudence of therapy. So I guess I find that Frank, while he didn't provide much rationale in Haelan for this, creating this public-private dichotomy, he had given a tremendous amount of attention to it in his scholarly works.
Yeah, I was wondering maybe you could spend just a moment touching on some of the evidence that you present in the paper for Frank's interest in and sort of reaction to psychoanalytic thinking.
Yeah, so I mean, he frequently cited Freud and Jung and Jean Piaget, and I mean, he was really very into this sort of psychoanalytic type thinking, which was big at the time. I mean, he was, as I mentioned, a leader in this American legal realist movement. He was known for several controversial articles and books like Law and the Modern Mind, which is considered today to be the foremost application of psychoanalysis to the law. He wrote that after undergoing an extensive 6-month psychoanalysis. He also wrote other books around the time of Haelan, such as Courts on Trial. He had the psychoanalytic jurisprudence, and he really, for him, the psychoanalytic interplay between these different parts of the personality, Freud's ego and id, Jung's persona and true self, supported his legal realist interpretation of judging as a highly subjective and indeterminate activity. He actually, invoking psychoanalysis, he thought that the conventional image of the law, that it was objective and precise, was this mask, this false face made to suit unconscious childish desires. He was concerned with distinguishing between what he himself labeled a public-private dichotomy, internal and external, psychic and physical, mind and body, subjective and objective, public and private. And he even proposed that every federal judge should undergo psychoanalysis so as to rid their mind of subjective biases. And according to some accounts, he actually tried to push this on his judicial colleagues, much to their chagrin.
Yeah, was he successful with that? Did he manage to get them all on the analyst couch?
I would highly doubt it.
Okay. So I was wondering if maybe you could provide sort of like a potted explanation of the kind of Freudian and Jungian theories that you think Frank was drawing on, and then say a little something about how those theories may have inflected Frank's decision in Haelan to sort of manufacture this new right out of whole cloth.
Sure. So it was Freud who initially came up with this theory of the divided self. I mean, at least in a mainstream Western sense. I mean, obviously it dates back much further than that, but Freud contrasted the what he called the id as the inner aspect of the psyche, which serves as the source of instinctual impulses, as compared with the ego, which is the external facing part of the psyche. Other psychoanalytic thinkers, notably Carl Jung, who today is perhaps most famous for his theories of introversion and extroversion, expanded on Freud's partition of the self into this outer self as contrasted with an inner or true self. And Jung actually called the outward face of the psyche the persona. And he contrasted that with the inner attitude of the person, which he called the shadow. Jung used the term persona, which originally meant in Latin theatrical mask, to indicate the public self of the individual, the image that she presents to others, as contrasted with her feelings and interpretations of reality that are anchored in her private self. So for Jung, the persona is how one appears to oneself in the world, but not what one is. A commodified part of the personality concerned with the relation to objects in the material world, a two-dimensional reality of an individual's true nature, a shallow, brittle, conformist part of the personality that's purely outer and collective, a compromise between individual and society, a mask that separates someone from their private life, a false self created by social pressures. So my sense is that this psychoanalytic concept of a personality divided into these inner and outer subparts maps onto the conceptual division that Frank articulated between privacy law as protecting against this exclusively psychic harm to dignity and emotion that is a true self, and publicity as protecting just the monetary, material, commodified value of one's persona, that is the false self, and that this divide could, plausibly have been motivated by Frank's following of psychoanalysis.
Yeah, I mean, from your description, it sounds like there's sort of like an implicit normative judgment embedded in both, to a lesser degree, the Freudian, but to a greater degree, even, it sounds like the kind of Jungian conception of the divided self. I wonder do you think that sort of normative element may have sort of encouraged Frank to look at the kind of public persona as being something alienable because it was in some sense sort of less normatively valuable in some way?
I think so, Brian, and I don't know whether, Frank meant to do this or whether it was, I guess, kind of, sort of more like a meta psychoanalysis of Frank himself. Maybe it was sort of this unconscious thing. But he had this background in the personality that divided it. And I think, when the right case came up, which was Haelan, it may have been that he recognized this, or he thought he recognized this division, and that he could give this new right to this other part of the personality that hadn't been legally theorized yet. That is the persona, the ego, this external facing, commodified thing. And he also made it alienable, which I think if you think of Jung's description as being this, shallow, brittle, commodified thing, it seems much more alienable. And I think it provided him some level of comfort in making this part of the personality that maybe wasn't the true self, something that could be transferred.
Yeah, right. It's almost like if it's not really all that valuable, you won't miss it so much if you sell it to somebody.
That's a great way of putting it.
So I wonder, Dustin, I mean, this sort of model that you're pointing to as sort of influencing or animating Frank's way of conceptualizing this dualism or dichotomy in the person, is this something still viable today? I mean, to what extent is kind of the modern doctrine of the right of publicity still a reflection, however darkly, of the ideas embedded in it from Frank? And should we think about it differently?
Yeah, that's a good question. The sort of subject-object split that Frank created, publicity and privacy. And I think maybe it may no longer be a great fit, psychoanalysis, that is, for purposes of personality rights jurisprudence. From a personality standpoint, the traditional psychoanalytic divided self has largely been repudiated given its emphasis on the separation between mind and world, inner and outer, and subject and object. You mentioned this dualism, sort of metaphysical or Cartesian dualism. Inner reality, under that view, is considered to be subjective and psychic, like privacy, while outer reality is objective, material, and extended into space, like publicity. But in contrast, I mean, I think more modern personality development has recently been found to be intersubjective in nature. Intersubjectivity meaning we negotiate our relations with others on a daily basis rather than having some sort of autonomous private core or true self at our center. Personality as a whole is sort of this social construction, I think, is the more modern view. And under traditional psychoanalytic thought, people are kind of viewed as trying to hide. You see that with Jung's shadow, or dress themselves up. You see that with Jung's description of the persona. But modern personality theory, this sort of intersubjectivity, doesn't try to fit people into pre-existing frameworks like persona and shadow, id and ego, true self and false self, or even public and private. These are rather metaphors that can be helpful in understanding people in some situations and some of the time. But from a more practical standpoint, the public and private is beginning to blur, given new media, digital network technology, social media, specifically. And this psychoanalytic concept of this inner private self and public false self may have been useful in Frank's time, where celebrities and private figures were distinct and had differing legal needs from everyday private citizens. But now, private people are living these sort of public lives on personal public spaces, like Twitter, for example. You have these communication spaces where people communicate and they're sharing things that are important to them. And people need to, the difference between privacy and publicity isn't quite so clear, in other words.
Yeah, I mean, I can't help but wonder, based on your description, whether it doesn't suggest that maybe sort of conceptualizing these rights as being distinct from one another and thinking about public persona rights as being sort of metaphysically different from privacy rights isn't perhaps the wrong way to go about it, and kind of maybe part of the reason the theories seem so awkward is that they're not actually describing the kinds of protections of people's identities that we actually want to achieve.
Yeah, that's a good way of thinking about it, I think. I mean, there are, of course, the classic right of publicity cases. I mentioned, Tom Waits, where a celebrity, has economic value in their personality, and what they're trying to do is prevent the loss of that economic value. But there have also been recent cases, class action litigations, and involving Facebook and LinkedIn, Fraley versus Facebook and Perkins versus LinkedIn, where plaintiffs sued under the right of publicity based on Facebook and LinkedIn's use of their names and likenesses for purposes of advertising and endorsement. And in those cases, plaintiffs had trouble recovering because they were private figures. Their injuries were dignitary and reputation and feelings based primarily rather than economic. And also that they had been found to have consented to a broad license of their personalities based on the terms of service of the social media. And so here they can't bring a privacy claim because they've let their images enter into the public sphere, but they also can't bring a publicity claim because their personalities don't have economic worth. So you see these cases kind of falling into the gap between the public and the private, and maybe what that shows is these harsh distinctions between the public and private don't actually exist in the way that the psychoanalytic theory, which may have influenced the right of publicity, led it to.
Okay. So in closing, Dustin, and this one's maybe a little abstract, so we'll see how it goes. But I mean, I'm wondering whether this kind of more dialectical approach to the relationship between private and public elements of a person's individuality pushes or ought to push our conception of the justification for the protection of those rights in a kind of economic and personal sense toward one or the other of the sort of paradigmatic theories of intellectual property, or whether you think it suggests that we need some alternative theory entirely, like some sort of tertium quid, different way of thinking about the justification for these kinds of protections.
That's a really good question. I'm not sure that we necessarily can analogize personality rights to a purely external theory of intellectual property. And I'm also not sure that it's totally analogous to privacy either. I think that there may be some middle ground between the public and the private. And I think that some scholars in the privacy jurisprudence have conceptualized a self that works for privacy. Helen Nissenbaum, Julie Cohn come to mind. These are scholars who talk about an embodied self. They talk about the self as a social construction, and I'm wondering if perhaps what publicity law could do is mine the privacy law scholarship for some ideas relating to the self, and then come up with perhaps a novel theory of publicity that in some sense integrates both intellectual property concerns but also privacy concerns, and that all still is very abstract and half-baked in my head.
Well, Dustin, it's been great talking to you about your paper.
Likewise, Brian. Thanks so much for having me on.
Penny?
Johnny Olson, where are you?
Dear, I'm stuck in the barrel of a cannon.
A cannon?
Well, you know our old friend Zapata the Great, the fellow who gets shot out of the cannon? Well, I stopped by the theater, and Zapata got me to try on his new cannon for size, and...
But, Johnny, you said you'd be sure to pick up our Halon bulbs. You know we've got to plant them right now. If we don't, we won't have any tulips or hyacinths next spring.
But, Penny!